In today's video, I've got a major update on the ongoing legal battle over California's rifle restrictions, specifically the Miller versus Bonta case. A recent unanimous ruling from the Supreme Court 9-0 is now being used as key support in the effort to overturn the state's controversial rifle ban. Let's walk through exactly what's going on. As I touched on in the intro, this video is all about the Miller versus Bonta lawsuit. It's a direct challenge to California's prohibition on what the state refers to as assault weapons. The case was just recently presented before a 3-judge panel in the Ninth Circuit Court of Appeals. It's been a long road. This case has bounced in and out of the Ninth Circuit more than once already. At the heart of the matter is the question of whether California's restrictions on certain rifles are a clear violation of our Second Amendment rights. Progress stalled for a while, but after the Ninth Circuit en banc finally issued a decision in the Duncan magazine capacity case, this one is picking up speed again. What's especially interesting is that the recent Supreme Court decision involving Smith & Wesson and the Protection of Lawful Commerce in Arms Act, also known as the PLCAA, is now being used to support the claim that this rifle ban is unconstitutional. In that ruling, multiple justices stated outright that AR-15 style rifles and similar semi-automatics are widely owned by law-abiding citizens for lawful uses. Because of that, they argued, banning these firearms runs contrary to constitutional protections. If you're not already familiar, Miller versus Bonta is challenging California's ban on what they define as assault weapons under Penal Code, Section 30515. That law bans numerous firearms, not based on function, but on cosmetic features. For example, if you own a semi-automatic centerfire rifle with a detachable magazine, you're not allowed to have features like a flash suppressor, a telescoping stock, or even a vertical foregrip. The presence of any of those features automatically classifies the rifle as an assault weapon under state law. The case originally landed in the courtroom of Judge Roger T. Benitez, known in pro-Second Amendment circles as Saint Benitez. After reviewing the arguments, Judge Benitez ruled that the state's ban does not align with the text, history, or tradition of the Second Amendment. As a result, he granted summary judgment in favor of the plaintiffs, those challenging the law. California, of course, didn't take that lying down. They appealed, and the case was accepted for review by a Ninth Circuit 3-judge panel. But once it landed back at the Ninth, things slowed down. The case remained stuck in limbo for quite some time, largely because the Supreme Court was dealing with a heavy docket of major gun rights cases, including the landmark New York State Rifle and Pistol Association versus Bruin decision. After the Supreme Court handed down the Bruin decision, the Miller versus Bonta case, along with several other Second Amendment challenges out of California, was remanded from the Ninth Circuit back to the district courts. That meant Judge Roger Benitez was once again tasked with reviewing the case, this time under the framework set by Bruin. As before, Judge Benitez found that California's so-called assault weapon restrictions still don't hold up under the Constitution. He reaffirmed that the law conflicts with both the plain text and the historical context of the Second Amendment. But as expected, the state of California wasn't satisfied and filed yet another appeal. The case landed back in the Ninth Circuit, assigned once again to a panel of 3 judges. Unfortunately, that's where the Miller case hit the pause button again. It was essentially benched while the Ninth Circuit en banc was still working through the Duncan magazine ban case. Oral arguments in Duncan were held, but then the ruling took nearly a full year, which meant Miller sat idle that whole time, too. Once the Ninth Circuit finally issued a ruling in the Duncan case upholding California's ban on so-called high-capacity magazines and claiming it didn't infringe on the Second Amendment, the Miller case was reactivated. Then, in January of this year, the panel assigned to Miller finally held oral arguments. Now, if you listened to that hearing, it was obvious just how slanted certain judges were against the right to keep and bear arms. Judges like Marcia Berzon and Jacqueline Nguyen consistently mischaracterized AR-15 rifles, at times calling them machine guns or even referring to them incorrectly as A-15s. It was pretty clear they lacked any technical understanding of how these rifles function or how widely they are used for legitimate purposes like personal defense, competition, and training. Both Berzin and Nguyen openly pushed back against the common use standard outlined in both District of Columbia versus Heller and reaffirmed in Bruin. They went so far as to argue that the test was circular reasoning. Even more surprising, Judge Ewan questioned the legitimacy of the data showing that millions of Americans own AR-15 style rifles. She tried to argue that even if ownership was widespread nationally, the numbers within California might not be high enough to meet the common use threshold, which is an odd twist considering the Second Amendment isn't limited by state borders. Since those oral arguments in January, we've been waiting for movement. And just recently, the Supreme Court delivered a unanimous 9-0 decision in the Smith & Wesson case. While that ruling primarily dealt with the PLCAA, it included strong language confirming that AR-15 rifles and similar platforms are in fact in common use for lawful activities. That language directly contradicts the narrative pushed by Judges Berzin and Ewan in the Miller hearing. The plaintiffs in Miller quickly filed a notice with the Ninth Circuit, pointing to that new Supreme Court decision and arguing that California cannot ban firearms that are clearly protected under Heller, Bruin, and now reinforced by Smith & Wesson. In their latest filing, the plaintiffs point out something significant. In the Smith & Wesson case, the Supreme Court outright rejected claims from the Mexican government that gun makers had aided and abetted unlawful arms trafficking simply by producing and marketing so-called military-style weapons. That includes rifles like the AR-15, the AK-47, and .50 caliber long-range rifles. The High Court unanimously dismissed those arguments, stating those firearms are both legally sold and widely purchased by everyday Americans. In fact, the court went even further, saying clearly that the AR-15 is the most popular rifle in the United States. Because these statements were essential to the decision, they aren't just offhand comments, they carry legal weight. As the plaintiffs in Miller make clear, the Supreme Court has already ruled that arms in common use for lawful purposes are explicitly protected by the Second Amendment. So, when the court says the AR-15 and similar rifles are widely owned by ordinary, law-abiding citizens, that directly undercuts any attempt by states like California to outlaw them. This creates a major problem for the three-judge panel currently reviewing the Miller case. During oral arguments back in January, the judges, especially Berzin and Nguyen, made it clear they didn't believe rifles like the AR-15 were in common use. But now, we've got a unanimous Supreme Court ruling saying otherwise. The only way for the panel to uphold California's rifle ban now would be to dismiss or twist the court's latest statements, claiming the remarks were just dicta or that they only apply to the PLCAA and not to constitutional law. But let's be honest, the Ninth Circuit has a long history of disregarding Supreme Court precedent. We've seen it after Heller. We've seen it after Bruin. The Supreme Court hasn't always stepped in to correct it either. They've declined to take up multiple challenges to magazine and rifle bans over the past few years, which has left the lower courts feeling emboldened. There's another layer to this situation. If the Ninth Circuit panel in Miller wants to dodge writing a ruling that openly goes against the Supreme Court, they have an easy option. They can just delay. They could say, we're going to wait to see what the Supreme Court does with Duncan, and then kick the can down the road again. That Duncan case, which challenges California's magazine capacity limits, was upheld by the Ninth Circuit en banc and is now being appealed to the Supreme Court. The California Rifle and Pistol Association is expected to file for certiorari on July 18th. Once that filing is in, the panel could claim that Miller is too closely tied to Duncan to move forward independently, and simply freeze the case again. As it stands, I believe the first final ruling we're likely to see from the Supreme Court will come from one of the other circuits, either the Seventh Circuit challenge to Illinois' so-called Protect Illinois Communities Act, or the Third Circuit case out of New York targeting rifle ownership. The Ninth Circuit has dragged its feet on Miller from the very beginning, and there's no reason to think they'll speed up now. That said, the Smith & Wesson language gives us a powerful new tool. It's now crystal clear that rifles like the AR-15, the AK-47, and even .50 caliber platforms are firmly within the scope of protected arms. They're owned by millions, used for lawful defense, training, and sport, and they're not going anywhere. As always, I'll keep you updated as this develops. Make sure to hit that like button, drop a comment with your take, and subscribe if you haven't already. And remember, this country was founded by patriots who understood liberty, and it'll be preserved by those who refuse to surrender it.